On the record in the matter of the people of the state of Michigan versus Kyrie Montgomery, file number 24-00371, council appearance.
Assistant Prosecutor Kate Petrowski on behalf of the people.
Your Honor, Assistant Public Defender Stephen Feigelson on behalf of Mr. Montgomery was standing to my right this morning.
How are you, Mr. Montgomery? I'm doing well, thank you. Today was the date and the time that was set for preliminary examination. What's going on with this?
The necessary witnesses have failed to appear and the people are unable to proceed today.
Counsel?
Yes, Your Honor, the defense motions here today to dismiss. Defense is ready to go. We are aware it is without prejudice and people can refile this, but nonetheless, we ask for dismissal.
Necessary witnesses were police officers?
They were the individuals who the charges for filing a false felony report, and the witnesses were people who were the alleged victim, or excuse me, the alleged perpetrators of the false police report.
Sorry, the victims are who?
And sorry, the language is a little silly. The witnesses who were subpoenaed, they, in the incident, were the ones who allegedly were firing a gun at defendant when that didn't actually happen, and that's where the filing of the false police report occurred. So the people who are saying that, the people who did not file a gun, the people who did not fire a gun, but who were reported to have done so, have not appeared.
Denali, without prejudice, so that means that the people do have the right to reissue this charge against you. Do you have any questions about that?
This is my first time.
Yeah, so without prejudice just means that they do have the right to reissue the charge against you if they later determine that they have sufficient probable cause to move forward, okay? If they do reissue the charge, you'll have to come and get rearranged. But you can talk to your attorney. He knows far more about this case than I ever will know. And he can explain to you the likelihood of that happening, considering why this case is being dismissed today. And then also the statutory timeline that the people have in order to reissue this charge against you. Do you have any other questions? Sir?
Oh, no.
Okay, any additional matters for the record?
Nothing for the people.
Nothing on behalf of defense, but myself and this might probably get a copy of the novel.
It's being done right now.
Awesome.
Thank you.
Yes, sir.
Thank you.
Okay, Ms. Donnelly.
Your Honor, I have in the
Ms.
courtroom.
Porter.
I have Betty Porter. I have Thomas Petty, and David Rhodes.
Okay, are we running Petty?
No, the necessary witnesses failed to appear.
On the record, in the matter of the people of the state of Michigan versus Thomas Petty, file number 23-02901, council appearance.
Assistant Prosecutor Kate Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Thomas Petty, who was present standing to my right.
Okay, how are you, Mr. Petty? I'm well, thank you. Today was the date and the time set for preliminary examination. The necessary witnesses failed to appear. How do you want to proceed?
Your Honor, this was the date and time set for a preliminary exam, so if they are unable to proceed, we'd be asking for a dismissal without prejudice.
Motion to dismiss without prejudice is granted. That means the people do have the right to reissue this charge against you. Do you understand that?
Yes, I do.
Okay, if that happens, you'll have to be rearranged. Do you have any questions? Get you a copy of your dismissal. Any additional matters for the record?
Nothing from the people.
Nothing from defense.
So you filling in for someone?
Love the game, Judge.
I love it. Okay, I don't see your name on here.
Nope.
Okay. Okay, on the record, in the matter of the people of the state of Michigan versus Betty Mae Porter, file number 23-02333, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Betty Porter, who is present and standing to my right.
How are you, Ms. Porter?
Okay.
Okay. You're welcome. Today was the date that we reset this matter for preliminary examination. Council was looking to have more time to review some medical prescriptions. And how are we proceeding at this time?
Your Honor, I have gotten medical records. I am requesting more medical records. I had Ms. Porter sign this week releases of information from McLaren and Ingham County Health Department. I believe that I will get the necessary records that I need from this request. And I've talked it over with prosecutor. We have no objection to a dismissal. My hope, or adjournment, I'm hoping that we can get a dismissal once I have the necessary records, and I think Ms. Petrowski is open to that.
That's correct, Your Honor.
How much time are you looking for?
I have the releases, I just need the records, so I would hope that I can have them within 2 weeks, but at the most 3.
Well, I think you said it's April 12th at 9. April 12th at 9 a.m. Ms. Porter, do you have any questions today?
No,
Okay, any additional matters for the record, council?
Nothing for the people.
nothing for defense.
You're all set. Joshua Day.
Your Honor, I was told yesterday when I tried to have a polycom with him at 3:30 that he went to the hospital. It's my understanding that we called down to lock up and he was not brought over, so I believe that he's still in the hospital, so we'll need an adjournment. And a good cause to adjourn.
Is that, he's in hospital?
He wasn't brought over.
And I did forward you communications from Ingham County regarding his medication.
Yes, I do appreciate that. That's what I was trying to do, follow up with him on those emails yesterday. They said he was he was taken over in the morning, but they didn't explain to me why.
Okay. I find good cause to adjourn due to the medical emergency and him not being transported over. Thank you, change of date. April 12th at 9. April 12th at 9 a.m. Ms. Robinson, Palmer, and other courtrooms today?
I'm covering for Robinson.
Okay, what are we doing with Becker?
I believe he failed to appear.
Oh, behind this
I'm sorry,
giant
Judge, I
tree?
was hiding.
Oh,
back
okay.
here.
I can't see back. Let's see. Becker. He was hospitalized previously. I don't know what's going on now. Oh, she was in charge. The record in the matter of the people of the state of Michigan versus Lyman Claude Hunter, file number 24-00182. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
If I could just grab my client out of it.
I could just do one last, while he's doing that, one last check for witnesses.
Are we expecting, I guess I'll ask Ms. Petrowski if she heard back from Mr. Carter? So,
I think he left.
his client is on Zoom now.
He was physically here.
Yeah, he was.
He had a PCC today. Did you and Mr. Carter conduct a PCC on Steele?
We had, I can't remember if I can open the offer yet or not.
His
But
client is on Zoom, but I don't see Mr. Carter,
he stopped by today because he wasn't sure if the prelim had been adjourned or not.
except for PCC.
Mr. Carter was in Judge Ward's.
Oh, okay.
Just a-
Okay, so Mr. Steele can type. Okay, where's Mr. Hunter?
Well, Judge, I was waiting because there's a, I mean, I can bring him in.
Yeah, I mean.
He's gotta come in because I called the case, so he's gotta come in because we're on the record.
Gotcha, I'm sorry.
Oh,
How are you, Mr. Hunter?
I'm good, how you doing?
I'm well, thank you. Okay, today was the date and the time scheduled for a retail fraud first preliminary examination. Are we ready to proceed?
Your Honor, I have one of my witnesses, but I do not have all of my witnesses. So we'd be able to start the prelim today.
Why don't you have all of your witnesses?
I don't know. I know that they were properly subpoenaed.
What witness do you have?
I have the junior court officer, Martel Smith.
A court officer for a retail fraud, but you don't have
Well,
someone
Judge,
from the place where the retail fraud took place? Is that what you're saying?
Yes.
Okay, counsel?
I was just gonna say, Judge, I guess technically she could start the exam today. I think it would make it a little weird because the court officer is here for purposes of identification. And presumably based on the report, but I don't know that, I mean, I guess the prosecutor can run the case any way they want to, but I don't know how we get to an identification if we don't first establish that a crime is committed. So that would be my position. And I would move for dismissal.
Looks like at least according to the affidavit of probable cause, there should be more than one witness from Quality Dairy.
That's correct, Your
That
Honor.
was subpoenaed. No one appeared.
No, we subpoenaed Faye Brown and Annette Couthen.
The motion to dismiss is granted without prejudice. We'll get you a copy of the dismissal. That just means that the people do have the right to reissue this charge against you, okay?
Thanks, Judge.
No problem. Just hang tight. He's got to get you a copy of your dismissal, okay?
Okay.
Thank you.
You're welcome. Did I lose Ms. Donnelly? She's handling roads, I guess, for Robinson. And we're waiting for Fileson. Mr. Steele?
Hey,
We're
good morning,
just waiting-
Judge Simmons.
Good morning. We're just waiting for your attorney to come. He's in Judge Ward's right now, okay?
Okay,
Have you spoken to him?
no,
Okay, we'll make sure you speak to him today.
Okay, thank you.
You're welcome. Good morning. Happy last day of Black History Month. How are you?
I'm good, how are you?
Pretty good. Let's see. Are you're here on Great House?
Yes.
Are we expecting to run an exam on that?
Yes.
Possible for Bazinski, possible Great House. What's going on with roads? We expecting, I don't know where Miss Donnelly went. I think she's on that one. And then. Who are you looking for?
My attorney.
She's probably in another courtroom. She'll be back. That's not. We got Mr. Milks here. He knows how to contact you.
Yep. Who?
Miss Donnelly.
I'm not getting over. Mhm.
She'll be back. on Bazinski and Greathouse.
That's correct, Your Honor.
On the record in the matter of the people of the state of Michigan versus Joshua Bazinski, file number 24-00360 FY, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
More Your Honor, Assistant Public Defender Stephen Feigelson, appearing on behalf of Josh Linsky, who's present to my right.
How are you, Mr. Bazinski? I'm doing well, thank you. Okay, today was the date and time set for preliminary examination. I have count 1, weapons, firearm discharge in or out of building. Count 2, weapons, firearm discharge from vehicle. Count 3, weapons carrying concealed. 4 and 5, felony firearm, and we're ready to proceed with the exam.
That's correct, Your Honor.
Yes, Your Honor.
Any preliminary matters?
Nothing for the people.
The only one I'd ask, Your Honor, is I think there's 2 witnesses. I'd ask for a sequestration.
Okay. Your witnesses.
I have Ms. Keisha Horn and, well, actually, there's 3. Ms. Keisha Horn, Mr. Cameron Frazier, and Detective Barker McGonigal.
Oh, okay. Sequestration is granted. I've seen Detective McGonigal in the hallway. Where's your other witness?
Ms. Keisha Horn is here, and Mr. Frazier is, I believe, in the jury room on the end.
Okay, looks like they're already sequestered, but I will advise them that there's a sequestration order. You can call your first witness.
Thank you, Your Honor. I'll get to call Ms. Keisha Horn. You're gonna go right up to where this chair is and just stay standing.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can have a seat, ma'am. There's a microphone that's in front of you. The young lady behind you is my court recorder. She needs to take down everything being stated here today. So your responses must be loud and clear so that we can hear them, okay? In addition to that, if there's an objection from either attorney, you will immediately stop speaking. That'll give me an opportunity to make a ruling on the objection, and then I will advise you if you can give that answer or not, okay?
Yes, ma'am.
We need yes or no's versus head nods and head shakes. Also, we can't understand mm-hs and uh-hs. So if you do respond that way, you'll just hear me ask, is that a yes or no, okay?
Yes, ma'am.
State your first name and last name and then spell both.
Keisha Horn, KeeShahorn.
We can proceed, counsel.
Thank you. Sorry, technology. Good morning, Ms. Horn. How are you doing?
All right, how are you?
Doing well. All right, so where do you live?
I live at 2212 Lyons Avenue, Lansing, Michigan, 48910.
And is that in Ingham County?
Yes, ma'am.
What kind of building is that?
It is a single house,
Like a residential
a
dwelling?
residential house.
So I want to discuss the events that took place on December 23rd, 2023. Did anything unusual happen earlier in the day?
It would have been December 12th, I believe, not December 23rd.
I apologize. So let's, so earlier in the day, what occurred that was notable to you?
That afternoon, there was a black Impala that pulled down the street, and they stopped at the stop sign, kind of out of the view of my cameras that are in front of the house. 2 gentlemen got out of the car, and they were walking up the sidewalk. They like walked past my house and was looking at the house, and had their hands in their pockets, and when they came up to the house, one gentleman wouldn't turn facing, or wouldn't turn around so the camera wouldn't see his face. Another gentleman, I think he thought he was out of the camera's view, to the side, and they knocked on the door. I was gonna open up the door, but someone told me don't open up the door, so I didn't open up the door. My kid's father yelled out like, "What do you want?" And one of the kids said that they were looking for my twin.
and we said that they weren't there. So they left. I called and made a report to the police.
And so I'm gonna stop right there and ask a couple questions. So when they came to your house, and, well, I guess you had said that you'd filed a report. Why did you feel that you needed to do that?
To be honest, my twins, which they're 17, they have issues with other kids. I don't know who the kids are, so to protect myself in my home, I filed the report.
And you said you had cameras out.
Yes,
Yes, I'm sorry.
no problem.
Where are your cameras pointed?
I have a doorbell camera outside of the house, that sees basically the front of the house. And then I have a camera on the inside of the house that points out of the window that can see more to the left down the street.
Are you able to see cars on the street from the
Yes,
camera?
ma'am.
And did you see a car when the boys came to your house?
Yes,
Did you take any photographs of that car?
I did.
And then, are those cameras continuously running?
Yes,
And are you able to upload and save the footage?
I uploaded the footage and gave them to the detective.
And did you recognize the boys? Did you know them?
I did not.
So, after you made the report, time goes on, we're gonna skip ahead a little bit to later that evening, on the 12th.
Yes, ma'am.
What were you doing that night?
Sleeping.
And were you at home,
Yes,
still in Lansing?
yes.
And where were you sleeping? Like, where in the house?
Downstairs in the living room.
And who was with you?
Me, myself, and my son, my kid's father. Justin.
Did you stay asleep that night?
No,
What woke you up?
gunshots. Bullets coming through my house.
How many gunshots do you remember hearing?
Probably between 7 and 9.
And what did you do after you heard them?
Immediately, probably.
What was going through your head in that moment? What were you thinking?
To be honest, I don't know. Emotions were everywhere. Frustrating. I don't know if they were so close, they were gonna come back. So it was a lot of emotion.
And were your cameras running at that time?
Yes, ma'am.
Did they capture footage of the shooting?
Yes, ma'am.
And did you download and save that footage?
I did. I uploaded and gave it to the detective.
Did you modify it in any way?
No, ma'am.
And was that footage a clear and accurate representation of what occurred to the best of your knowledge?
Yes, ma'am.
This is the technology right up here, but I'm going to pull up people's proposed exhibit number 1, which is the surveillance footage of. Just could you allow me to share my screen with Zoom?
Since I have to do it.
Oh, it's you. Oh, my apologies.
Let's see, how many people host?
So, sorry, do you recognize this, I guess, opening frame of the video?
Yes, ma'am.
And what is it?
That is the camera pointing out of the front window.
And that is a clear and accurate representation of what that looks like
Yes, ma'am.
from your security camera?
Yes.
At this time, people have moved to admit people's proposed exhibit number 1.
Any objection?
No objection.
People's one's a minute.
I'm not gonna play People's Exhibit number 1. So if we have audio problems, we'll audio did not play.
Did you click, you have to click play audio before you share screen. So exit the share screen. And then this time when you click share screen, on the right hand, it should have an icon for you to click share sound. You see it?
I. And my
Okay,
apologies.
you can approach.
Do you want to bring it?
Nope, I'm just gonna show you what it looks
Thank
like
you,
on
I'm
my
so sorry.
computer. Does it look like this on your computer when you click share screen?
Oh, okay, I was just on the screen before that,
Yeah,
so,
it's only you put share sound right there.
thank you.
No problem.
There we go, okay. Thank you, everybody, for your patience. All right. Try to see.
Deanna, somebody, Keisha. Did you hear that shit?
So, at the end of that video, whose voice was that?
Jeffrey.
And that's because he was present with you.
Yeah.
Did you recognize that vehicle?
That was the vehicle that was present earlier in the day.
And so you said after the shooting, you called police.
Yes, ma'am.
Did they come to the residence?
Yes, ma'am.
What did they do?
They made a report. They took the, I'm sorry, I'm trying to, this hearing that I just brought back.
I'm sorry.
They made a report. They took down, the pictures that I had uploaded on, outside.
And did you examine the front of your house after the shooting?
Yes, ma'am.
Did you notice anything different about it?
Yeah,
Could you describe that?
I have bullet holes outside. the door.
You know how many?
I do.
And were those there prior to December 12th?
So there was a couple prior there to December 12th. I would say that it wasn't, but the majority came after the shooting.
No further questions.
Cross examination.
Morning, Ms. Hunt.
Good morning.
So in the afternoon on the 12th, you said you get I see 2 people coming up to your door. Is that correct?
Yeah.
I know they were looking for your sons.
They kept me after.
And you've never seen those 2 individuals before?
One of the kids, there was a white male that was facing, that did all the talking. He was familiar because my kids went to school with him.
Can you describe what that white man looked like?
He's shorter, kind of chunkier, and he had like a bunch of facial like brown hair.
You said there was another individual. Can you describe what that individual looked like?
He wouldn't look at the camera, but he was taller and he looked like he was biracial. He had Put over his head, you can just see that his hair is sticking out of the top. But when they walked away, I stepped out. They weren't driving the car. They were in the back seat of the car. And that's how I was able to zoom in and get pictures of the license.
Gotcha. They said one of those individuals, the individual that happened to be white, you said you thought you would recognize from going to school with your, one of your twins, is that correct?
Correct.
But you don't know his name.
I believe his name is Caleb.
You've never met the other person before, is that correct?
I can't say I have or have not, because like I said, he did not look at my camera.
You said they got into the back seat, is that correct?
Correct,
Before that time, you have never seen that car before, is that correct?
correct,
And then you said later in the day, and at nighttime, the car comes back, is that correct?
correct. As I looked at my camera, the car like drove by the house, I want to say 2 to 3 times before shooting occurred.
Okay, and you didn't see it, so you're not sure if it came from the front seat or the back seat, or
Correct.
you just heard the shots, is that correct?
I gave the information to the detective. They found the kids. I was told, and they told who else, what else occurred.
So let's go back up track. You said that when you looked, there were several bullet holes in your house that were before this incident. When did those occur? So
There was a couple.
March
Not
before
several.
this?
Yeah.
What happened then? You know, who shot at your house then?
I do not.
But since March, no one else has shot at your house, is that correct?
Correct.
And your twins were not at the house, is that correct?
They were not.
And is it true they're runaway status, is that right?
That day, that night, yes, they had took off.
Okay. You said you had seen this Caleb before, is that correct?
Caleb.
Caleb, I'm sorry.
And correct.
How often have you been at the house?
He hasn't been at my house over there. This was probably 4 years prior. Probably told with them.
I don't have no additional questions for this one.
You had said that you were able to see the 2 boys get out of the back seat of the vehicle. Were you able to see who was in the driver's seat?
I did not, because I walked out quickly and took it really quick before they were able to pull off, and I didn't know what was being leery. I didn't know what could occur, or if they were gonna turn around, or like I said. I didn't get advice from them, so I didn't open up the door, and they still kept their hands in the pocket until they got back to the car.
No further questions.
May this witness be excused from the stand?
Yes, you may.
Okay, I'm going to advise you that there is a sequestration order, so that means you're not allowed to discuss any portions of your testimony with any other potential witness, okay? Thank you, you can be excused.
Thank you.
You can call your next witness.
Thank you, Your Honor. People call Mr. Cameron Frazier. I will go.
It's a sequestration order, so she can't stay in. No problem. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat. Okay. there's a microphone that's in front of you, and right behind you is my court reporter. She has to take down everything being stated here today, okay? So all of your responses must be verbal. Okay, and head nods and shakes or mhm and ahs, we can't write that into the record, so if you forget, I'll ask you if it's a yes or a no, okay? Keep your voice up loud and clear so we can hear. Also, this last thing could drown out a little bit of sound. If there's an objection from either attorney, you will stop speaking immediately. I'll make a ruling on the objection, and then I'm gonna tell you if you can give us that answer or not, okay? State your first and your last name and spell both.
Cameron Fraser, Camron, last name Fraser, Fraser.
You can proceed, counsel.
Thank you, Your Honor. Good morning, Mr. Frazier. How are you doing?
Morning, good.
All right, so I want to talk about an incident that occurred on December 12th, 2023. Does that day stick out to you? And why does that day stick out to you?
Because I was forced to,
I can't hear anything he's saying.
because I was forced to do something I didn't want to do.
Since Frazier is speaking up and nice and clearly so you can hear. Okay, so let's talk about how that started. Do you drive a, or I should, what's your vehicle?
It's a 2008 Chevrolet Impala.
And do you, on that day, did you pick up some people?
Yep.
Who did you pick up?
I picked up my friend Caleb and my friend, one of Caleb's friends, he's closer with him. He's light skin with curly hair. And I was hanging out with them for the majority of the day until I got later in the night. And then we went out to Grand Ledge area and picked up Josh.
Did you know Josh?
I met him a couple times before and we were acquaintances. I wouldn't say we knew each other.
Would you recognize his face if you saw him?
Yes, ma'am.
Is he present in the courtroom today?
Yes, ma'am.
Can you describe where he's located and an article of his clothing?
To the left of the defense, and he's wearing a black suit with a jacket.
Let the record reflect that the witness has identified the defendant.
Any objection to identification?
None, Your Honor, but I'm gonna cross the line.
Okay, so noted, identification is noted.
Thank you. So you went to Grand Ledge and picked up Josh.
Mhm.
Did you know why you were going to pick up Josh?
I thought it was just hang out, you know. I like to spend time with my friends and hang out. Usually we just smoke or have fun, listen to music, freestyle, just do our thing.
And so what did you do after you picked up Josh?
We drove towards Lansing and we were kind of in a neighborhood near Potter Park.
Had you been there before?
Yes, one time.
When?
I'd say 3 or 4 days prior to the incident.
What were you doing?
Picking up Caleb's friend.
Picking him up?
Yeah.
Did you make any stops in that area?
Yes, in his house.
At his house?
Yeah.
Did you see him come out of his house?
Yes.
So when you went back to the neighborhood by Potter Park, can you walk me through what happened?
At what time of the day?
I guess, did you go there multiple times?
Yes, I went there earlier with Caleb to pick him up originally. I think he had to go to work that day, and then we went back there to pick him up after.
The first time that you went there, around what time was that?
Say a little bit afternoon.
And the second time that you went there, what time?
Just start with the dark.
When you have Caleb's friend, and Josh in the car, where's everyone seated?
When Josh was in the car, he was up in the passenger seat up front. Caleb was in the back passenger behind Josh, I believe.
And you were driving.
Yes.
So did you know when you were going to that house why you were, or going to that neighborhood, why you were going?
I had basically heard that they kind of got into like an altercation over somebody stealing something. I didn't know that they were going to take any tactics with them. They were angry about it.
So once you got to the neighborhood, what did you do?
I drove around the block multiple times while they were trying to look for the house. Once they found the house, Josh had reached his arm out of the vehicle and unloaded.
So did you know that Josh had a gun initially?
Yeah. No, not when I was picking him up, but when he got in the vehicle. It was,
Where was he keeping the gun on this person?
on his lap.
And what kind of gun was it, you know?
It was a little short compact black gun.
Was it a handgun?
Yeah, it was up outside, so I didn't get a really good look at it.
But you knew it was a gun.
Yes, ma'am.
So then, after you had driven past the house multiple times, Josh then, you said, stuck his arm out the window?
Yep.
And you said that he unloaded a clip. You mean that he shot
Yeah.
at the house?
Yes,
And could you see where he was aiming?
kind of up towards the windows. It was like kind of at the corner of the house.
Okay. Was he saying anything before this happened? Did he ask you to stop?
So kind of forced to stop. When the gun was fired.
He pointed the gun at you and told you to stop,
Well, told me to drive past that.
or told you to drive past the house? What were you thinking when he pointed the gun at you?
That was into
How were you feeling?
a dangerous situation.
So how many times do you think that he fired the gun?
Honestly, I don't recall, but it was several.
Like more than, did you say more than two?
Yeah, definitely.
Less than 20? Okay, give me a big range. So after he fired the gun out the car, oh, and I guess I should correct, he was fully in the vehicle, or his body was in the vehicle while this was happening. What happened after he fired the gun off?
We had taken off and a couple of streets away, I was told to get out, put the plate back on the vehicle. So I did that and Caleb hopped out as well. And then after that, we kind of went east towards East Lansing and then shot straight down southbound. And we went towards Caleb's house. The other person that was in the vehicle failed at some point in between here and there. So we got to Caleb's house, we stayed there for the night. The next day, me and Josh went toward the house he was at in Grand Ledge. And after I stayed for multiple days too. So I was told that I could leave, and then I went with my mother.
So I got a couple questions about that. So first, you said that you, after a couple blocks, you got out and put the plates back on the car. When did you take the plates off the car?
The plates were already off the vehicle. Like,
So the plates were already off the vehicle?
yeah, like 10 to 15 minutes before we started driving towards their house.
Were the plates on the vehicle when you drove there the first time? Did you take the plates off the vehicle before you drove there the first time?
I did. I wasn't able to play.
Do you know who did?
I believe it's Caleb.
And just so I'm making sure that I'm clear, when I say going there the first time, I mean earlier in the afternoon when Josh wasn't with you. When it was just Caleb and the friend.
Yeah, no, the plate was on.
Plate was on the vehicle at that time? Okay. But later, when you came back in the evening, that was when plates were taken off.
Yes.
And you weren't sure who took the plates off?
No, I'm pretty sure. It's Caleb.
Oh, you were pretty sure it was Caleb. Okay. So then you said that you went back to Josh's house. Why did you go back to Josh's house?
I couldn't hear.
I was forced to.
And what do you mean by that?
He had a gun and he was threatening my life because he police were catching.
And he had told you that or communicated that to you verbally? I'm sorry, I missed. How many days did you stay at Josh's?
A few days, I'd say.
And when you had said that you had left after you were able to leave, is that correct? Well, what do you mean by that?
I was getting a bunch of calls from the detective wanting to be questioned by the police. I told them that it would be better questions, kind of just take the heat off us a little bit, because my vehicle was in the driveway and I needed to be looking for it. So I kind of explained that it would be better if I wasn't there, so that it would be harder for me to tell.
Did you end up speaking with police?
Yes.
And did you give them your statement of what happened?
Yes, sir.
Did you initially give a fully truthful statement? And why was that?
Because I was in fear of my life.
But did you give a correct statement or a truthful one? So, earlier in the day when you picked up Caleb, that was one time that you were in that neighborhood in Lansing.
Yes,
Was that the only house that you stopped at?
Yes, and then came to Trent's house. We had stopped there earlier to pick him up before we went towards where the shooting happened.
And so you did go towards where the shooting happened?
We went there earlier during the day, because Kaylin wanted to go and speak to them about what had happened. And see if they actually stolen something from them or if, they just misplaced it or accidentally put it back.
So when they wanted to go talk to them about the potential stealing, that happened around that same time that afternoon. Did Caleb and his friend, did they exit your vehicle to do that?
Yes.
Did you exit the vehicle?
No, I stayed in the vehicle and I waited on the street. They walked up to the porch and they were gonna knock on the door to see if one of the twins would come in and speak to them.
And did one of the twins come to the door?
I don't know.
No further questions.
Cross-examination.
So I want to turn your attention back to December 12th. So said in the app about noon, you go pick up Caleb, is that correct? How did that arrangement? Did he call you? Or was it a pre-arranged?
It was a phone call and Snapchat.
Said, hey, yo, come pick me up, basically.
Yeah. I think so.
So pick him up at about noon, then you go pick up his friend, is that correct?
Yes.
Have you met his friend before?
Yes, we had went to high school together.
But you don't remember his name? Remember talking to law enforcement?
That day?
In December, you spoke to law enforcement, is that correct?
Yes.
Didn't you gave the name to law enforcement then, is that correct?
Yes.
Do you remember the name now, right? If not, I can show you the report to refresh. Remember. You don't know someone by the name of DAE, is it?
Day.
Day.
I was just having a hard time calling his name.
So Dave was the other person in the car.
Yes.
And you went to school with him, is that correct?
Yes.
Pick him up after you pick up. Is that correct? And just the three of you were together, is that correct? And then at that point in time, you go to the twins' house, is that correct?
Yes, sir.
Do the twins have a name?
I don't know.
And Caleb and Day thought the twins took something from them, is that correct?
Yes. So day.
So the feud was between Day and the twins, is that correct?
Yes, sir.
And you drop, what time you drop Caleb back off at his house to go to work?
That wasn't Kaylin that we dropped off at this day, sir.
Okay, what time you drop Day back off?
Like 15, 20 minutes after we were at the twins' house.
What time do you go to the twins' house?
I don't.
This is after you went to the twins' house the first time, you're saying? You dropped Day off?
No, Day was with us when we went to the twins' house. Shortly after we left the twins' house, we had taken Day back to his house so we could get ready for work.
Oh, okay.
What do you and Caleb do while Day's at work? What do you guys do the rest of the day while Day's at work?
Honestly, we were just driving around. I had drove into Francis Park, and I had parked my vehicle there, and we had smoked, and kind of were just talking around and waiting to
So
see
you
what
were
day
you
we
smoking?
We
How much weed did you smoke?
used to smoke that day.
Enough to influence your ability to remember what happened? Like any other legal substances?
No, sir.
And then at what time of day do you go back and pick up Day?
Shortly after 5 o'clock.
And somehow you guys said you go out to Grand Ledge, is that correct?
Yes.
You know how that got arranged?
Kaylin had gotten off the phone with Josh, and Josh said that he was down for hanging out.
You went to go pick him up, is that correct?
Yes, sir.
Have you met Josh before?
I had met him a couple times prior, yes.
When was the last time you saw him before that day?
We were hanging out at one of Kaylin's houses with him and a bunch of other friends.
But you only knew him through Caleb, is that correct?
Yes, sir.
Do you know if him and Day were friends?
I believe they were.
What is Day, can you describe what Day looked like? What Day looks like?
He's light skinned with a puffy afro.
Then you said about what time of day did you go pick Josh up?
Say about half an hour to an hour after we picked up Dave from work.
So about 6 o'clock. Where'd you pick up Dave from work? Where's he work?
McDonald's.
Which McDonald's?
I believe the one on Cedar right across from the AutoZone.
So the whole area, basically. After you get to Grand Ledge, what do you guys do next?
We picked Josh up and then we start heading back towards that.
What time do you start heading back towards Lance?
Shortly after we got there, so anywhere from 6 to 7 o'clock.
It was dark at that point. okay?
Yes.
And then make any stops along the way?
I believe I stopped to get gas in the direction.
Eventually you go back to the twins' house, is that correct?
No, we went back towards Lansing and we had hung out for a little bit prior to the gun being pulled out. But we were around in that same area, yes.
And then, so you know about what time of day you go to the twins' house?
No, I don't.
Have you ever met the twins before?
Only in school because they had went to a whole, like my freshman year.
And you said you were driving, is that correct? Can you describe the gun you saw?
It was short and black, kind of like a compact type pistol.
Then you said, now, isn't it true at that time your mom lives in Tennessee, is that correct?
Yes, sir.
And you were classified as a runaway, is that correct, on December 12th?
Yes,
And you were staying with somebody in Beverly Ballard, is that correct?
yes, sir.
You give the statement to law enforcement on the 16th, is that correct?
Yes, sir.
And at first you lied, is that correct?
Yes, sir.
You give them the story that somebody stole your car, is that correct? Then they call you out on your not being truthful, is that correct? And you change your story? Get a deal or any offer of community to testify here? And you meet with them in February, is that correct? You meet with this young lady over here in February? How long are you guys at the twins' house the second time? Whenever you were with Day, was Josh there as well?
Yes.
Anyone else present besides the four of you?
I don't believe so, but there could have been.
Okay. You mean it could have been, you mean it wasn't, it wasn't.
I don't really remember how many people were in the backseat. I was kind of just worried about my life.
Fair enough, but you picked up people and you said for a while everything was going on. Now you're not sure if there was more people in the car.
Well, I'm not sure who popped in after Josh had shot up.
So you're talking about after the.
Yeah.
Did you meet up with your girlfriend Leah later in the night? And you met her at the Love's truck stop, is that correct? Is that in DeWitt or
I'm pretty sure it's up to us there. Yes.
off of 69, right?
Yeah.
Were you there? Why were you meeting your girlfriend there?
To pick her up.
You pick her up, where do you take her?
She went.
What's the relevance?
Goes to his story of events where he goes directly to Josh's house after the event.
Yeah, I'm trying to understand what's the relevance of picking up his girlfriend. To these charges.
Or it was Melvin to tell the truth.
Credibility, you mean?
Great, yes. Good.
I don't think it's relevant.
I'll move on. So after you go to the truck stop, you go to Josh's house, is that correct?
Yes.
And at that time, your girlfriend was in the car, is that correct?
Yes.
You know anybody else?
No, just me and my girlfriend.
You had dropped off Caleb and
Yes,
Dave.
Caitlin was at his mom's house. No, they had built out of the vehicle.
when did Dave out of the vehicle?
When we were heading southbound with Caitlin's house. After the incident.
Josh and your girlfriend go to Josh's house, okay? Yep. Your girlfriend stayed there with you guys?
Yeah, she stayed with me.
And you also could have stayed there because you were a runaway, wanted to continue to be on the run, is that correct?
No.
I have no further questions for Mr. Brady.
I have a question. You mentioned that you were forced to go to Johnson's house because you were threatened for your life. Did he say something that made you feel threatened for your life? What did he say?
He said that if I ever opened my mouth, he would eventually catch me for it.
He would eventually catch you? Okay. And did he say that to you while pointing the gun at you, or the pointing the gun took place when he told you to drive off?
That was when we were driving.
Okay.
That was when we were
Okay. And what did you understand, I'll eventually catch you later mean?
If I said something to the police after, because he said this as I was leaving his house.
Okay.
I feel like that was just a threat to try and keep me to keep my mouth.
Okay, thank you. Any redirect?
The first time that you stopped at the twins' house in the afternoon, did you see any lights on in the house?
No,
You see any cars in the driveway?
no, I didn't pay attention to that. I was just saying about that.
What about the second time when you went that evening?
The second time, I didn't notice anything, porch light on. That was about it.
And this whole dispute, you were saying that it was because something was stolen. What was stolen?
I
Or
believe
like
it was money.
money? If anything else could have been stolen?
I don't know.
And when Josh pulled the gun out, when the first time that you saw it, where did he pull the gun from?
It was a waste man.
Other questions?
I asked a question. Did you have any cross-examination based on my question?
No, you're.
May this witness be excused?
Yes, he did.
There's a sequestration order. I'm going to advise you, you're not to discuss any portions of your testimony with any other witness, okay? You can be excused. You have another witness?
I have Detective McGonigal, but if I could just speak with you real quick.
No, I was gonna say I need about 2 minutes anyway,
Oh,
so.
perfect.
After. Have you spoken to your client?
Trying to call him now.
He's on Zoom. If you want to log in, I can put you in a room.
All right, thank you.
We need to- Okay, back on the record. In the matter of Joshua, of State of Michigan versus Joshua Bazinski, are you calling an additional witness?
No, Your Honor.
Is the defense intending to call any witnesses today?
None for purposes of preliminary answering, Your Honor.
Argument.
Thank you. Today we heard testimony from Ms. Keisha Horn and Mr. Cameron Frazier. Ms. Horn spoke about her interactions with some young men coming up onto her front porch earlier in the day on December 12th, 2023, at her 2212 Lyons Avenue address in Lansing, Ingham County, state of Michigan. She spoke about how they were coming up to her house looking for her sons, looking about some sort of property that may have been stolen, and that she was able to get a clear picture of the vehicle with its license plate on it. Later in the day, she was taking a nap, sleeping in the living room with her boyfriend, when she was awoken by multiple shots being fired at her house. She could see fresh bullet holes in the siding of her house. Her security camera captured it, captured the same vehicle driving by, and captured the audio of the shots being fired. And additionally, she stated that police were able to find multiple bullet casings in the street. From the testimony of Mr. Frazier, who was the owner of the vehicle, we heard testimony that he was forced at gunpoint with his life being threatened to drive the vehicle back to the residence of Ms. Horn by a Joshua Bazinski. Mr. Frazier identified Josh. He knew him as someone he had as friends of a friend, and had interacted with him before, and was able to positively identify him. Joshua pulled the gun out of his waistband. It was small and black. He had pointed it at Mr. Frazier, told him to drive past the residence, and then told him and then put his arm out the window and fired the firearm multiple times at the residence. As such, he discharged the firearm intentionally from a motor vehicle in a way that would endanger someone else, given that Keisha and Jeffrey were asleep in the house presently while it was being fired upon. Luckily, no one was injured, but their lives were definitely endangered, especially given that Mr. Frazier testified that he believed that he saw Mr. Bazinski aiming the firearm at the windows of the house. For the charge of discharge at a building, again, that the defendant fired a firearm intentionally at a building that they had reason to believe was either a dwelling or potentially occupied structure. This house was in a residential neighborhood. It had a front porch light on, and they had gone to the house earlier that day, or the other people involved in this had gone to the house earlier in that day, looking for people who they believed lived there and could be present. So again, I believe that the elements for that have been satisfied. Mr. Frazier testified that Mr. Bazinski had the pistol in the vehicle, and that he knew the pistol was there. He had it in his waistband, and because he took part in carrying it and using it, those elements are also met. Additionally, the 2 charges of felony firearm, those elements have been met because he did in fact use the firearm when he discharged the weapon at the building and when he discharged the firearm out of the vehicle. Additionally, Mr. Frazier's testimony leads to has led to additional charges in this matter. I think it's very clear that a account of felonious assault took place when Mr. Bazinski pointed the firearm at Mr. Frazier and told him that he would, if he said anything to police, he would catch him. Mr. Frazier was very afraid of this. He took that threat very seriously, and given that a firearm was pointed at him, I think it is completely reasonable to say that to a probable cause standard, the elements of a felonious assault have been met, and additionally that a firearm was used in that felonious assault. And so we would be asking for this case to be bound over with the initial charges as charged and with the additional charge of felonious assault and an additional charge of felony firearm for the use of the firearm in the felonious assault upon Mr. Frazier.
Okay, you're requesting an added count 6 of felonious assault and added count 7 of felony firearm.
That's correct.
Any other argument?
No, Your Honor.
Let me see, give me just a moment. Okay, you can proceed, Counsel.
Thank you, Your Honor. Your Honor, as in this case not be bound over as charged, let's talk about a couple of different things. The standard of proof at a preliminary exam is there probable cause to believe there was a crime? Then the second element, which I think where I take issue is probable cause to believe that this defendant committed the crime. Right? I think that's where I want to focus on. I want to talk about a couple of things. Let's talk about Miss Horn's testimony. Doesn't know who fired out of the car. When she sees two young men outside her door, she sees two kids that don't have any resemblance to what this defendant looks like. She doesn't know if it was this defendant. If you listen to the testimony of Mr. Frazier on this, Mr. Frazier said Mr. Budinsky wasn't in the car, it was the other two young men. These other two young men were, particularly the one day, is the one that had the situation with her sons, the twins. What I can understand, my client didn't have anything to do with what happened between Day and the twins. At least there's been nothing to establish anything to say that, Your Honor. Let's look at the testimony of Mr. Frazier. He's a runaway. He's admitted to being not truthful in his first statement, Your Honor.
What does this being a runway got to do with anything?
Goes to his credibility, Your Honor. He has motive to lie.
Close to where he lives. Just because you're a runaway doesn't mean you're gonna lie under oath. Just means you ran away. Runaway is not a crime of dishonesty.
Fair enough.
Thank you.
What is, I think he lacked the credibility to be truthful today, Your Honor. He wasn't certain who was in the car after the event. But picks up his girlfriend later. If he really threatened, I already make all these extra stops with my client in the car. I don't think there's enough evidence here for that, Your Honor. It has not found the worst charge. Thank you.
Today was the date set for preliminary examination, and as indicated by your attorney, the standard here is probable cause. What wasn't indicated by your attorney was that this is a very low burden. This is not a trial. It's not beyond a reasonable doubt. We just need more than mere suspicion here. That's it. We had testimony here from two witnesses, one being Akeisha Horn. She's a witness indicating that she lives at the address of 2212 Lyons Ave, City of Lansing, Ingham County, State of Michigan. That makes venue in this court appropriate for this matter. She stated that on December 12, 2023, in that afternoon, that a black Impala pulled down her street, stopped about the stop sign. Two men got out the car, walked past her house. One man would not turn around, so she couldn't identify. The other, she believed, thought he was out of the camera's view. They knocked her door. The kid's father asked, what do they want? And she said they were in search of her twins. The witness testified she later filed a police report indicating that, her children, her twins, sons being 17 years old, having some issues with other kids. Also, it should be noted on the record that her sons are listed also, I guess, as runaways. She had a doorbell camera, which was presented as the People's Exhibit 1, which is a video that showed an incident that she described that happened later that same day while she was sleeping downstairs in the living room with her kid's father on the sofa, and they were awakened by gunshots spraying the home. And that video did showcase there was a bullet hole, but it does not appear that that bullet hole was the result of this incident. She did testify about a previous shooting incident that she was not aware of when or who performed that shooting, so that there was some bullet holes already at her property. But the court did see the video played in People's Exhibit 1, which displayed a black Impala drive down her street, the witness's street or victim street, and slowed down, and that there was a sound that indicated or sound like gunshots being discharged in the direction of the victim's home. The witness testified that she was familiar with the one of the males. She described him as a white male, and that she believed that his name was Caleb and that he attended school with her children. The other guy she described to be taller, looking biracial. Again, but she was not familiar with who that person was, and she said she saw two boys get out the back seat, but she did not see the driver. We had testimony then from Cameron Frazier. He testified that on December 12, 2023, he was forced to do something he did not want to do. He described an incident where he picked up an individual identified by name of Caleb and picked up Josh, and that they had spent some time at Potter Park earlier in that day, that he overheard an altercation regarding someone stealing something from someone, that they drove around the block a couple of times. He testified under oath that he was instructed to drive to this area, that he circled the block a couple of times, and that Josh, the person he identified in the courtroom with wearing a black suit and a red tie, got out of the vehicle and emptied his clip at the home. He then testified that Josh pointed that same firearm at him and told him to drive past the house. He gave testimony indicating that the plates from his vehicle had been removed. He was not sure when those plates were removed, but that those plates had been on his vehicle prior to that shooting incident. He said that he was pretty sure, however, that Caleb was the one who took the plates off. He testified that he was forced to go back to the home of Josh because he was threatened for his life, or what he believed to be a threat on his life, and to prevent him from speaking to the police. And when questioned by the court, he testified that threat included a statement somewhere to the effect of, if you ever say anything or make a statement, I'll catch you later. And so he said he didn't initially give a truthful statement to law enforcement when questioned by law enforcement due to the threat for his life. He gave an initial statement indicating that his vehicle had been stolen. He then testified that he later gave a truthful, or what he believed to be a truthful statement of the account of events that he testified he witnessed to the law enforcement. Count 1 is weapons, firearms discharged in or at a building. If this were to be found over and to go to trial, the people would need to prove beyond a reasonable doubt versus defendant discharged the firearm. Second, that the defendant did so intentionally, that is, that it was done on purpose. Third, that he discharged the firearm at a building that he had reason to believe was either a dwelling or a potentially occupied structure. The jury instruction describes a dwelling as a building where people usually live. It does not matter whether or not someone was actually living in the building at that time. A potentially occupied structure is a building that a reasonable person knows or should know was likely to be occupied by one or more persons due to the nature, function, or location. It does not matter whether a person was actually present in the structure. Based on the testimony that we have here today, and I found the testimony of both witnesses to be overwhelmingly credible, and they testified, particularly Mr. Frazier testifying, that they had driven past this house earlier during that day, knocking the door. And then they returned back to that home, that they were reporting to that home to look for someone. So the home or the building already being described by Ms. Horn during her testimony as a single family dwelling in a residential neighborhood, and it was occupied by her at the time and by her child's father. The court is satisfied that there's sufficient probable cause as to count one that will be bound over to the circuit court. Count two is weapons, firearms discharged from a vehicle. That at trial, the people would then have to prove beyond a reasonable doubt first that the defendant discharged a firearm, second, that he did so intentionally, that means it was on purpose, and third, that he did so from a motor vehicle, snowmobile, off-road vehicle, fourth, that he discharged a firearm in a way that endangered someone else or caused physical injury to someone else or caused serious impairment of a bodily function or caused death to another individual. In this particular case, we have testimony from both Ms. Horn and Mr. Frazier indicating that on the date in question, the person identified in the court as Joshua Bazinski did discharge or empty his clip at the home that was occupied by the victim, Horn. The concern the court has is that the testimony that doesn't make clear that that happened from the vehicle versus happening that they got out the vehicle and emptied the clip. But that I think is more of a question of fact. There was testimony that there was a discharge, that he drove his vehicle and that he would, the firearm was then pointed at his head for him to drive off. I think that the court can assume that there was a discharge from the vehicle when it came to emptying the clip. So count two will be bound over to the circuit court to accompany count one. Count three, weapons carrying concealed, will require at the time of trial for the people to prove first that the pistol was in the vehicle that the defendant was in. Second, that the defendant knew the pistol was there. Third, the defendant took part in carrying or keeping the pistol in the vehicle. I think we've had testimony today of there being a black Impala, which the defendant, Josh Badinsky, was identified as being a passenger in. I think they said that he was in the they said Josh was the passenger in the front seat. Nonetheless, that there was a firearm that he removed from his waistband, and that would cause the court to believe that he knew that there was a firearm in the vehicle and that he took part in keeping the firearm in the vehicle. So count three will be bound over. Count 4 and 5, both felony firearms, one going to the discharge at the building and the other going to discharge from a vehicle, will require the people to prove at trial that a person was actually, the person has actual physical control of the thing, as I do this pen that I'm holding here. I have control over this pen. Also, they would need to prove beyond a reasonable doubt that the person knows the location of the firearm or had reasonable access to it. This was a testimony about the defendant having both access and control and use of a firearm. Doesn't matter who the owner was. Count 4 and 5 will be bound over as the court believes there's sufficient probable cause to those counts. The people are asking for an additional count of assault, that being added count 6. And the people would need to prove that at trial beyond a reasonable doubt. First, that the defendant either attempted to commit a battery on, at this juncture, it would be against Mr. Frazier, or did an act that would cause a reasonable person to fear an immediate battery. A battery is a forceful a battery is a forceful, I'm sorry, you asking for assault with a dangerous weapon or felonious assault? That's the same one. I'm making sure I'm reading the right jury instruction.
Yes, Your Honor. I believe it's the same charge, felonious assault, which is
17.9. Okay. Again, beyond a reasonable doubt, they would have to prove that the person being the defendant either attempted to commit a battery upon Mr. Frazier or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, that the defendant intended either to injure Mr. Frazier or to make Mr. Frazier reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought he had the ability. And fourth, that the defendant committed the assault with a dangerous weapon. The court is well aware that a pistol is a dangerous weapon. The testimony of Mr. Frazier was that the gun was pointed at him and he was made to drive off. And then also a threat about if he gave a statement that he would be found later. I think that threat and that action, if occurred, would have caused Mr. Frazier to fear an immediate battery, and it would cause a reasonable person to fear an immediate battery. So the court will add count 6 and count 7 of felony firearm to be attached to or accompany count 6. Those will all be bound over. So counts 1 through 7 will be bound over to the circuit court. Your bind over date is going to be the 13th of March. That's the date the circuit court will get the file from the district court. That's not the date that you need to appear in circuit court. Do you understand that? Is that a yes? Your next court date is going to be a pretrial in circuit court, and Mr. Feigelson will be made aware of that date. All right, we need to address bond. Bond was set at 5,000 personal recognizance. No contact order in place for the protection of Keisha Horn. I'm going to first amend the bond to include a no contact order for the protection of Cameron Frazier. I think the bond was set too low. Counsel, did you want to address bond?
Yes, Your Honor. I think given the testimony, especially given the threats for retaliation against Mr. Frazier, that those would lead to concerns that I also have for Mr. Budzinski to be out and in the community. And so I would ask for a cash surety bond placed on Mr. Budzinski.
Mr. Feigelson.
I think bonds appropriately set. Again, I want to talk about the testimony of Mr. Frazier, Your Honor. I don't know if I still don't believe there's enough evidence to bind over, but Mr. Budzinski is here. There's been nothing to indicate he's made any additional statements other than what Mr. Frazier is alleged to have occurred on this night back in December. There's been no other evidence to suggest anything else has occurred, Your Honor. I don't think there's enough evidence here to warrant modification of bond today, Your Honor.
My concern, the allegations, there's overwhelming probable cause. I recognize you dispute that, but the testimony is what the testimony was. We have an eyewitness who identified the defendant in court and a person who testified he drove the vehicle in question. This is not someone who was around the corner and alleged to have seen the incident. He was the person who allegedly picked these people up and drove them allegedly to the location. The concern the court has, though, is the allegations of, well, first, the allegations are that there was a discharge at a building and from a vehicle, and then followed up by threats that if the alleged driver were to give a statement that there would be some retaliation. And so this is additional information that was not given to the arraigning magistrate at the time that she did the arraignment. And so she did issue a bond at 5,000 personal recognizance. I think that under the circumstances, it is too low, and it does not sufficiently provide security to the public or to the alleged victim in this matter now being Mr. Frazier, because he would be now listed as a victim in this matter. And so for that, the court is going to amend the bond. Bond will be amended to 5,000 cash surety with GPS tether and victim notification if possible. He's going to be remanded into custody until bond is posted. There's a no contact order. You're not to have contact directly or indirectly with Mr. Frazier. Do you understand that? Do you understand that?
Can I say something though?
Answer my question.
I do understand.
Okay, so you're not to have contact directly or indirectly. That means you can't have any third-party contact. You can't have anybody else make contact on his behalf.
Can you take this one? It's twisting my arm. It's like.
Okay, okay. You have a question?
Yeah, I was trying to say like, because I don't understand, like, just sitting up there listening to his story.
Don't say anything else right now.
I'm just saying.
Okay, so you don't have anything, any question for the court? Any additional matters for the record?
Nothing for the people you're.
You're all set.
Gonna,
Mr. Carter,
Yes,
our client continuing to examine, so we need to give you an exam date.
we are, and the court view or the court system has it already scheduled for April 18th. Is that not a good date?
Day of for this training or something. Okay, nope, that's not a good date. There's an MJI training, I think that date. It looks frozen. Okay, I think you're frozen. Can you hear me now?
Yes, I can.
Correct. Yeah, no, there's an MJI training that date, so
Okay,
it needs to be reset.
Can you do
all right.
Can you do the 12th of April?
I can make that work.
Okay, we'll do April 12th at 9 a.m.
Thank you.
Thank you. You're all set.
Thank you.
Okay, are we ready on the next exam?
Yes.
do it after lunch. He's in custody.
Okay, I'll come back. I'm gonna do something that work.
Yeah.
I'll be back about 1 o'clock, Judge.
Yeah, that works.
All right, thanks. Have a nice day. See you, man.
You too. You need a notice too. Is that what you're looking for?
Yeah, unless you want to mail it.
They're printed in there?
Yeah.
That's for, okay.
Want me to send it to my client?
I can send it out if you don't. put mine.
You good? Yeah, you need anything? Okay. Sage wanted you to. Oh, yeah. Yeah, there's that. Yeah, one, she just wants you to know you're still around. Okay. I'm also putting it on it. I haven't never in it. No, I didn't even, she just told me about it, so I have no idea what it is about. So you Donnelly covering Phil Robinson? Okay, because Donnelly's. Yeah, just lost her. Yeah. Just asking here that she's. I didn't know that. Okay, I told my husband to tell her to be complicated what she does, but. Him and Kyle. The mileage. Yeah, so half a day is $6 and it's 10 cents a mile. So right. Yeah. Right? Yes, thank you. I didn't go to law school for that. Yeah. Yeah, yeah. Avoiding. Doing my own stuff. Procrastinating, because that always works out well for me.
Yep, I'm tomorrow.
Yeah.
How are you looking?
I'm good.
No. Much.
Well, I've got mostly chaos. I've got one who was,
Right.
got one who's supposed to be here for PCC today. I have another file. And shows, so I know ridiculous.
One down.
And then I got one with Michael Sandberg. It's a 2022 case. And my witnesses are. I don't even know. So. I don't know what to do with that one.
We locate Miss Donnelly or someone?
She is on the record in Buchanan. Mr. Feigelson has said that he will let her know what she's done to come over here.
Okay, sounds
I am ready with Mr. Hayward's PV though.
good. That won't happen until probably 1:30, 2 o'clock.
Okay.
Yeah, but we're all just doing an exam.
Gotcha, thank you.
Yeah.
I have two PCCs. 2017.
Oh my God.
I do think I'm shooting for them for.
Okay. Still.
Also my sheet.
Right, yeah.
She's a friend over these and I still cry. Which is not cool, but
John, the other day, he's like, hey, I've got this conference next week and I've got this 22 count in front of Flores that I need someone to cover. And at first I was like, oh God, is it like it's insurance fraud? So luckily it was just the PCC and the P got out. So
good. Yes.
John should be back. But I don't want to do this. I mean, it's mostly just things are going left for me. It's not all business records, but it's just like. Between that and my.
I took the elevator with Diana with the other day.
Did you really?
She was coming in for something. I was like, hey.
Yeah.
She's like, yeah. I've seen so many emails with your name on it.
Yeah.
I'm like, you're here all the time.
All the time. It's like all she does.
I'm like, lovely. She said, oh God, do I?
Yes.
I very briefly had to look at that case.
Yeah, that one's another 22. And it's just, it's so much.
Yeah.
That it's just.
Yeah.
Just clean up. And like, big from or Jamie. That's how it works.
They only have 4 pieces. So I can.
Oh, that's nice.
Help run crazy people if you need.
I'm trying to think, I got one that's gonna be.
And let's leave. Oh, okay, you got them all. I guess I see BBs in each regulation.
Yeah, I have had less of them, although I had one that was up for PCC today. No, it was interesting. So that's fine. That was one next to you about where I yelled at. Yes. Not so much yelled, but I'm like, yes. Just like got really squeaky.
They can get that sweet.
She's like, oh, squeaky. The cicadas are horrible person. Don't tell me what I know. Okay.
Okay.
You see, this is not getting anywhere.
David Rhodes, file number is 24-00234, council appearance.
Assistant Prosecutor Pete Petrowski on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Aaron Robinson with the client, Mr. David Rhodes, who is present and standing to my right.
Thank you for your patience, Mr. Rhodes. Today was the date and the time that was scheduled for a preliminary examination of carrying a concealed weapon. How are we proceeding on this?
Your Honor, at this time, it's my understanding that the prosecutor is prepared to proceed with Trooper Golden. I have had discussions about whether we were going to proceed or not, but I haven't had actually been able to speak to Mr. Rhodes after learning that the state is ready to proceed. So at this time, I would like a moment to speak with Mr. Rhodes and then hopefully go back on the record.
We have plenty of time. So I'm about to run a whole exam and then my staff's gonna get a lunch break. And so you can talk to him.
I talked to him before. I just need a moment, if I could step out, maybe just for 15 seconds, and then because I just want to confer with him.
Okay.
Hold on.
1 more second.
I won't timer. Yeah.
Your Honor, to that time.
Back on the record?
Yes, at this time, Your Honor, with the necessary witnesses ready to proceed, we'll be waiving this preliminary exam and having it bound over to the circuit court.
Okay, and the people want to waive?
Yes, the people also unconditionally waive their right to.
Okay, Mr. Rhodes, can you step, oh, I can see you above there. So you understand that you have the right to have a preliminary examination because you're being charged with a felony?
Yes,
And you understand that the purpose of that exam is to require the prosecution to put forth evidence to establish if they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. You understand that?
yes,
You want to waive that?
yes.
You sure?
Not sure.
You don't have to waive it if you're not sure. You can ask more time to think about it.
Okay, I'll ask for more time.
Okay, and how much time do you think you want to think about it? Do you want to just take lunch and then come back and tell me, or do you want another day?
Can I take a lunch?
You can take a lunch and come back and let us know.
Okay, thank you.
Okay, be back here around 1:30.
Okay.
Okay, thank you.
Yeah.
Okay, and this was Great House, correct? Okay, on the record in the matter of the people of the state of Michigan versus John Greathouse, file number 23-03639 FY, council appearance.
Assistant Prosecutor Petrosky on behalf of the people.
Bobby Fickman on behalf of the defendant, Mr. Greathouse, who's standing to my right.
How are you, Mr. Greathouse?
Good morning, Your Honor.
Okay, today was the date and the time that was scheduled for a preliminary examination on false pretenses, 1,000 to 20,000. Do we have preliminary matters we should address before we proceed with the exam?
Nothing from the people.
Nothing from the defense.
Okay, call your witness.
Thank you. The people would first call Ms. Kimberly Sellers to stand.
You're good. She's got some stuff on her hands, so she needs some assistance.
We'll do stuff. Yeah.
Have you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. And can you state your first and last name and spell both?
My name is Kimberly Sellers, AIMBERLY SELLERS.
Okay, and you've testified in court before?
I have.
Okay, you can proceed, counsel.
Good morning, Ms. Sellers. How are you doing today?
Good morning, I'm well. How are you?
I'm doing well. Where do you work?
I work for the U.S. Department of Labor, Office of Labor Management Standards, OLMS.
And what is your title?
I'm a senior investigator.
And what do you do in that role?
I investigate labor union criminal cases, election cases, and compliance audits.
In your role, did you at any point begin an investigation into a Mr. John Greathouse?
I did.
And how were you made aware that an investigation was needs to take place?
So our office, we enforce the Labor Management Reporting and Disclosures Act, which governs labor unions. We actually take calls from the public. Typically, we have calls from members concerned that their executive board officers, their president, vice president, treasurer might be embezzling funds, hence the criminal investigations. We also take calls regarding election concerns. This particular case came to us through a concerned member from the labor union, American Postal Workers Union, Local 488, 489. He was a steward. His name is James Steele. He came across the financial records of the local as a steward. I'm not exactly sure how that happened. I'm not sure if he was newly appointed. So when I initially got the call, the information that he gave to us was that there was a belief that their editor, who was an officer of the local, Mr. John Greathouse, was embezzling funds, misappropriating funds through use of a policy called lost time, misusing that policy. So after that, I actually, instead of just opening a criminal investigation, we opened a compliance audit. During the compliance audit, when I went in to meet with the current president, Ms. Dale Prosper, and the current treasurer, Janelle Rambo, they both informed me that they had spoken to Mr. Steele and basically given him the information after looking at the local records that they believe that some misappropriation had occurred, and Mr. James Steele then contacted my office.
So I guess,
I just want to pause. I know that some of the other witnesses aren't supposed to be in
Oh, are they?
court, Mr.
Well, there was
Prosper.
never, no one made a motion
Okay.
for sequestration order.
Okay.
Are you
I
requesting?
just wanted to.
yes, my apologies, Your Honor. Other people would be requesting sequestration.
Okay, sequestration is ordered, so you have to step out. Thank you.
Thank you for bringing that to my
No problem.
attention, to the court's attention. So you were contacted by Mr. Steele.
Mr. Steele, who was prompted to contact us by Mr. Prosper and Ms. Rambo.
And he was alleging that there was potentially some, I guess, fraud or something taking place using the late time policy, or the, excuse me, lost time policy.
Yep, and I can explain further what lost time is.
That was gonna be my next
Okay.
question, so thank you.
So lost time is essentially when union officers have to conduct union business. It could be grievances, arbitrations, things like that. And their time to conduct union business conflicts with their regular employer schedule. They request unpaid leave, or they're supposed to, from their employer in this case being the Postal Service. During those times, because they will be missing out on their regular pay, the union will then reimburse them to make them whole. That's lost time.
So when someone applies for lost time or submits lost time, are they also getting paid by their employer?
No, they specifically should not be getting paid by their employer, not any type of paid leave or regular wages.
And is that policy the union's policy, or is that a legal law that's has that?
It's a union policy, correct.
Okay. So when you begin, or what were the first steps that you took when you began your investigation?
So the first investigation actually started as a compliance audit. Initially, when I went in to look at the records, I contacted the United States Postal Service, the employer Office of Inspector General, to get the records. That's a normal policy for my agency, is to contact another administrative agency. And that was to get the time of attendance records for Mr. Greathouse, because he was the potential subject of the investigation. I reviewed the records, and then I reviewed the union records as well. And those are in the form of a voucher, which have the date, time, the number of hours, and the amount that the person is being reimbursed. And I cross-referenced the information against the postal record. So I compared what was paid by the union to Mr. Greathouse to what was paid by the Postal Service, or not paid.
And when you were cross-referencing those would have the dates and the times for what the supposed work attached.
Correct.
And when you did that cross-reference between those two records, did you find any discrepancies?
Yes, many discrepancies.
Can you talk about that a little bit?
So the first set of discrepancies was with regard to annual leave that was paid to Mr. Greathouse. There was 14 instances between 2016 and 2020. I would have to look at my notes for the exact date, but there was 14 instances in which he was paid annual leave, so vacation, from the Postal Service on days in which he turned in a form PS 3971 to the union, claiming that he had not been paid for those days. So he was double dipping. He was being paid by both the Postal Service and the union.
And you could see that based off of the looking between the two records for when he applied for pay.
The dates matched up. Yes.
Okay. Do you know how many times he used this I guess strategy to double dip for his pay from the union and from the U.S. Postal Service?
So the 14 instances with the annual leave requests, there was an additional 17 instances in which Mr. Greathouse was using a method of banking lost time, where he had attended work for full day's wages, so he had no wages that would have been lost, and he was on his personal time and conducted union business, grievances, things like that. He kept it on a personal log of his, and then at a later time would request unpaid leave on later days and supplement time from this log on those days to be paid. So, for example, he would request on, say, January 1st, or I'm sorry, January 10th, 8 hours of union leave without pay. But on January 1st, he had worked a full day's wages, but then an additional 4 hours he worked for the union on his personal time. Because he had received a full day's wages on January 1st, he wasn't entitled to receive any lost wages for those 4 hours that he worked for the union. So he kept it on the log. On January 10th, when he requested the 8 hours of unpaid leave, he only actually worked for the union 4 hours. Those other 4 hours he would have had to have eaten, but he would supplement from his personal log this time to essentially be paid those additional 4 hours.
Is it standard practice for a union member to, yes, keep their hours stored in a personal log to supplement them?
Absolutely not. All of the, and Mr. Greathouse has been told this, when we had our interview, that's one of the first things I brought up to him. There are records where he's been told very pointedly not to maintain a personal log of hours. During one of the witness interviews, the former president, Ms. Lisa Jackson, explained to me that she had a conversation with Mr. Greathouse early on where he requested to use this practice. He wanted to go to the Postal Publisher Association, a separate labor organization, some kind of conference. And he asked if he could accrue hours.
Yeah, I have to object for hearsay.
Sure.
Ms. Jackson's here to testify, so the witness does not get to speak for her. If she wants to testify to that fact, she can do so at that time.
Oh, you said Ms. Jackson is here to testify?
She is.
Okay, well, whether she was here or not, this witness can't testify to what Ms. Jackson said, so objection is sustained.
So,
So no, to answer your question, it is not an approved practice. It's been written in the meeting minutes. He's been told directly. The former president was actually charged and convicted on a very similar charge for abusing lost time. And from that, this conversation in the meeting minutes directing Mr. Greathouse not to utilize this practice, that's where it came from.
right. You had said that there was a date range from that these double dippings or these instances where he would file for extra time in violation of the policies. What exactly was that date range again?
If I could look at my notes.
Yeah.
I also have the meeting minutes. So the first date range for the use of the annual leave ranges from February 2016 through July 2020. And the use of the banking of the lost time ranges from November 2017 through March 2020.
Through those, so those are two distinct ways that he would go about getting extra compensation that he was not entitled to.
Correct.
For the first being for the filing for the lost time, when in fact he should not have been. Do you know how much money or wages he had obtained from the union?
So the total wages, let me go back to that. So for the use of the annual leave, that first method was $2,475.05. And for the use of the banking of the lost time, that was $4,931.82.
As far as the union's policy on how they keep track of reporting of hours by their officers, do you know what the union's policy is on that?
The vouchers, or what it, the union uses expense vouchers, and it's everything from lost time to reimbursed expenses, mileage, things like that. and the payee, the person requesting reimbursement, fills it out themselves and they sign it at the bottom, attach any backup documentation. In this case, for lost time, the backup documentation is the PS 3971, which is the request for leave from the Postal Service.
So then the union and the Postal Service, they would then rely on what's being represented in those vouchers to determine the pay is given out.
Correct. The union relies on the integrity of the person requesting reimbursement, and the Postal Service really has nothing to do with it. The union doesn't typically go and talk to the employer. They don't verify. They rely mostly on the integrity of the payee, the officer.
And you said that you yourself had spoken with Mr. Greathouse, is that correct?
We did have an interview last April.
Did you interview with him in person?
I did.
And did you see his face when you spoke with him?
Yes, he and Mr. Ficklin. Yes.
Oh. And would you recognize him if you saw him today?
I would.
Is he present in the courtroom?
He is.
Can you describe where he's located in an article of his clothing?
He is wearing a blue suit with a blue and gray tie, seated next to Mr. Ficklin.
Thank you. I'll let the record reflect that Ms. Sellers has identified the defendant.
Any objections, to identification?
No objection.
Identification is noted.
Why did you start that conversation with Mr. Greathouse?
It's standard practice. We interview witnesses beyond doing just the records review during the investigation. Typical practices, we conduct the records review, create schedules of what we believe to be misappropriation. But before we're going to approach the prosecution, we're going to ask the officers of the union, is this right or wrong? Because what may seem inappropriate to our agency, they may have someone within the union that authorized it, that said that it's okay. The three witnesses I spoke to, Mr. John Jewell, the chief steward, the former president who was in office at the time this occurred, Ms. Lisa Jackson, and then Mr. Maceo Cosper. I interviewed them first to make sure that what I was looking at, I was on the same page. I wasn't misreading their bylaws. And then we conduct finally the subject interview. So we have information and I make sure that I hone in on what is an actual misappropriation. Because there were other parts of this case where I believed initially could have been inappropriate pay to him. After speaking to the officers, it was believed that wasn't necessarily approved, but it wasn't necessarily inappropriate. So that part of the questioning was really removed. So we make sure to speak as standard practice to the subject lastly.
And with those instances where you thought there potentially had been misconduct, but there wasn't actually, those wages, those were not included in either of the two totals you had spoken about previously.
That's correct. No, they were not.
Okay. So when you met with Mr. Greathouse, basically, what did you kind of initially ask him?
The initial format is to gain background. How long have you been with the union? What titles have you held? What's your experience with the union? Have you attended any trainings? And then we go into kind of the policy of lost time, what his understanding of it is. And then we begin to move into the actual schedules of the alleged misappropriation. I was only able to begin to review the annual leave schedule. The banking of the lost time we didn't get to because Mr. Greathouse actually ended abruptly our interview and left. The point of asking for their experience, their tenure, their background with the union is, did you know what you were doing was wrong? Did you have training? Should you have known?
And how long had Mr. Greathouse been with the union?
A number of years. The dates range. Mr. Greathouse, I believe, told me it was between, I would have to look at my notes. The numbers are escaping me. Some folks said 10 years, some said 12. It's been a great number of years. I believe he said he's been with the Postal Service for 35 years. He's been a member of APWU Local 48849 for about 32 or 33 years.
So when you discussed with him the policies of the union, did Did he understand those policies?
When I read off some of the bylaws and the information to him, there wasn't very many direct answers. He said that it sounded correct. It sounded accurate to him.
No further questions.
Cross-examination.
So as you stated, hi, how are you?
Well, Mr. Bickley, how are you?
Good, pretty good. Now, you stated that Mr. Greathouse abruptly left the interview,
He abruptly left again. Yes, sir.
and isn't it true that that was after you berated him and accused him of lying?
I did accuse him of lying. Yes.
And I instructed him to leave the interview, correct?
You, as I recall, said, well, she's already called you a liar, and do you want to go? And asked him to leave.
Now, you also stated that in your direct testimony that you need to fill out a 3971 annual leave slip to receive lost time for annual leave. Is that correct?
I'm sorry, ask that again?
According to the policy, you stated that you would need to fill out a 3971 annual leave slip.
My understanding from the policy is that a 3971 is required as backup in addition to the voucher being submitted to the union to be reimbursed for lost time.
Correct. As well as code 84, you need a 3971 slip as well, correct?
Correct, to request code 84.
Now, discover any annual leave forms, 3971 forms that Mr. Greathouse actually signed according to the policy.
Correct.
So when you base your assessment that he's receiving annual leave as well as lost time, how is he authorizing that? Because he would have to submit a writing, correct?
I don't know if he had to submit it in writing. What he submitted in writing or what I have record of is the 3971 showing the code 84 was requested.
Correct.
The other records that I have is showing on his actual time and attendance sheet from the United States Postal Service. It's called a tax report, TACS. That shows that he actually took code 55, which is annual leave. So I have the time and attendance reports showing that he actually took the leave, and I have the 3971s that he submitted to the union showing that he requested code 84 and that he was in fact reimbursed code 84 on the same dates.
Now, is it your understanding that it's Mr. Greyhouse's position or his job to fill out those reports or to do any of his expense reports? Because although it does state annual leave, what led you to believe that he initiated the request for annual leave? Because there's no writing.
When you're saying filling out the reports, are you saying the time and attendance reports?
Correct.
So the time and attendance reports actually capture. So whether or not he requested it or not, he actually took the day off as paid leave, annual leave. So it shows the actual badge swipes. He wasn't there. He was paid for annual leave.
And you know that he requested that how?
And how do I know that he requested that?
Yes.
That I don't know if he requested or not. I know that he took it as unpaid leave. I did request from the Postal Inspector General's office, copies of the 3971s. But by the time I got into them, they no longer had those records. They said they only typically keep them like 12 months.
Okay. So at this point, they don't exist.
As far as I was told.
Okay. Now, I also wanted to ask you a few more things about the policy. Since Mr. Greathouse was serving as the editor, he's allowed to bank some hours, correct?
No, not my
The
understanding.
policy does not state the local policy?
No, sir. There's no local policy that allows him to bank time. Need some water.
I thought it was just me.
Well, according to-
I mess with Simmons. It's just me as a hire.
Well, no, you're.
That's what I'm on.
It was
Probably
happening
me.
over there too. I'm like, my eyes are watering, my nose is running, what's happening?
Now, it appears that the local union's bylaws, that's the constitutional bylaw that was included in your report, that in section 7, entitled the editor, the compensation to the editor should be $500 per year in salary plus payment of lost time not to exceed 16 hours per issue. The paper will be published a minimum of 4 hours, but not to exceed 6 times per year. The editor's dues will be reimbursed in December of each year. So would you interpret that as he's allowed to bank some hours?
No, no. The banking of the hours and what we're talking about in the context of this is an actual Excel spreadsheet that he was keeping. And he did on occasion track the 16 hours per pacer issue. But he also had numerous times where he would take an NLRB phone call, National Labor Relations Board phone call. He would handle a grievance at an associate office, and it would be 3 hours, 1 hour. He was tracking any duty that he was conducting for the union, be it on personal time or lost time. But that's not an authorized practice. What that definition is that you're reading to me is just what he's entitled to as an officer. How that is tracked, how he is given the 16 hours of lost time is each time he produces the newsletter, which is the pacer, then he fills out this voucher, and his proof for those 16 hours is that the actual newsletter has been produced and sent out to the membership, and they reimburse him those 16 hours. He shouldn't be keeping it on any kind of a personal log. All of the witnesses I've spoken to have said that, and that's in the union's record.
That all of the witnesses stated what?
That there should be no log of lost time. This has been an issue that's been brought up in the past.
Well, let me just ask you this, because I don't want to get off topic.
Sure.
Now, couldn't that be his understanding of the policy that he's allowed to make hours? And it seems to me that keeping them in a log would show integrity, that he's being transparent. You don't agree with that?
No, I don't agree with that. And the reason I don't agree with it is, even if that is his understanding, when someone comes to you and tells you this is a practice that is not authorized, when you go to one of your other officers and ask, can I use this practice? Can I continue to accumulate hours or accrue hours using my personal time so that I can go to this other event? And you're pointedly told, no, that's not authorized, that's not okay. At that point, I would hope that you would understand to desist from that practice.
Well, with that being said, Ms. Sellers, wouldn't it be Mr. Greathouse assuming the risk of not getting paid, because those hours still have to be approved by the president of the union for lost time?
No.
So there's been times where he wasn't paid because he banked his hours and they did not approve that. So wouldn't he assume the risk of not getting paid if he held that log of personal time? I'm sorry, of the banked hours?
No, if you have unpaid leave that you've requested from the Postal Service to conduct union business, you hand in your 3971 for whatever number of hours it is. You hand in your voucher and say, I handled this particular union duty on this date. Here's my purpose, and this is the dollar amount I should be reimbursed for it. That's your proof right there. If you have the 16 hours that you will be paid as editor of the local, once you turn in or produce that newsletter, that's your proof right there. There should be no reason to keep track of it.
So I have a question, and I don't mean to throw off your rhythm, but just because this log issue is coming up. So when you're saying he's keeping the log, if he has to turn in this form, is he not allowed to keep a copy of that form as his record, or?
Sure,
Oh,
absolutely.
he could do that, but just the personal log was the issue.
The personal log, when he's turning it in and requesting time to be reimbursed to him, and that the time that is on that log, some of it has already been paid regular wages from the Postal Service. That's what's not authorized.
Okay.
Lost time is simply to reimburse you to make you whole again.
Correct.
Right.
Now, the fact that you say that he's already been paid some of those wages allegedly, that's what I mean as far as the annual leave. Do you have any proof that he also had annual leave? Because the issue in the case is whether he took from both simultaneously, correct?
Yes.
Now, do you have a written or someone stating that he told them that he was requesting a 3971 annual leave specifically as well as lost time at the same time?
No, as indicated previously, I don't have the 3971s, and I wasn't provided that information apparently doesn't exist. What I do have is the actual date of the occurrence that he actually took annual leave, and that's in the kind of tenant reports. I have copies of those here.
Correct, but again, he's not in charge of facilitating those reports, correct? So there could be errors.
He is in charge of his time. To say that it exists in a vacuum, that he has no idea. You.
Well, I
took
never
the day-
said that. I don't want to
Okay,
misspeak. I don't want you to misinterpret.
so
I'm just asking, is there room for error
I
in your
understand.
investigation?
I understand what you're getting at, right? Because he stated that in his interview with me, right? That he can't control what the Postal Service management inputs for him, right? He requested unpaid leave, allegedly, right? Requested unpaid leave for union business, code 84. And on those dates that he requested it, union management put in annual leave as vacation for him. That's not his fault. He didn't request
Well,
that.
did you ask any of the management, did they do that? Did they actually make an error?
No,
So have you haven't spoken to any of the
No.
managers?
no.
No further questions.
Redirect.
So, I apologize. So, basically, I kind of want to, because, Mr. Ficklin sort of, you didn't fully finish answering your last question there. So if you would, as part of my redirect, if you would like to continue answering that question.
Sure. So, to say that he did not, Mr. Greathouse did not request the annual leave on the dates in which he requested code 84. He turned in the code 84 PS 3971 to the union, thinking he's going to conduct union business that day and going to receive non-payment of wages. For him to say that he was completely unaware that management then inputted a vacation day for him, he would have gotten his paycheck in a week or two, and seeing that, anticipating that his paycheck is going to be less than it normally should be because he requested
I
one
have to
day,
object.
2
This
days,
calls for
3 days off.
speculation.
You said the objection is cause for speculation. Did you want to respond to the objection?
I guess I think that she's speaking more in a hypothetical. She's not necessarily she's not speculating about specific instances of Mr. Greathouse. She's explaining how the system itself would work.
Okay, the question, so the issue or that what she's responding to is whether or not it's likely that his supervisor would have put in vacation leave for him,
Whether or not he would
or whether he
be
would have known,
aware, whether or not he
aware there
would,
was an error.
right, whether or not he would be, whether or not someone would know they were receiving either more or less money than they were anticipating based off of.
Agreed. I don't think that's speculation, because I think that if I get paid today was payday, and I typically get this amount of my paycheck, and then there's more in there, I probably am gonna go to my stub and see why is there more. So I don't think that causes speculation. I think a reasonable person would do that.
Wait, I'm sorry, Your Honor. I just wanted to add, well, that would still cause some speculation to assume the person would be checking their own financial records, whether the spouse is the one that's in charge of their finances and not.
That's likely
I
too.
mean,
That's likely
so
too,
that's-
but
it's
that
just-
sounds like a question of fact, though.
That's true.
Which is for the
That's true.
jury.